Section 30 of the Indian Contract Act speaks about wagering contracts. That means, that is, it is said, where there is a chance of one person winning and another person losing. Here, as far as wager is concerned, it is supposed to be a speculative transaction between a person and the other person. And mostly what happens is, we find these wagering contracts in our day-to-day life as on today. Here, normally, cricket betting which takes place, whenever international matches are held, there's a lot of betting that goes on. They say, suppose India wins, the other person says Pakistan will win. We do not know whether India is going to win or Pakistan is going to win. It is dependent upon an event which may or may not happen, and it is highly speculative, and there is no chance of a person winning always. Then you take the case of a rummy which is played, that is a 3 cards, or the cards game which is played, and there normally, though you win initially, later on you lose everything, including your last piece of cloth in your body. So such a type of contract is called a wagering contract. But of course exceptions are made to that, because the government itself has legalized certain types of contracts. For example, horse racing. In horse racing, what happens is, it's a source of revenue for the government, where horses run and bettings take place. And of course, I don't play races, but there are different types of prizes that are awarded. One is called jackpot. That is when you win the race, the entire amount which is pulled up by way of the punters depositing that money comes to you. Or there is another thing called Tanala. Tanala is when you win 3 rounds and the 4th round you lose, then you get that prize. Like that, you have got different types of prizes as far as horse racing is concerned. Horse racing is legalized. So the question is, though it is in the form of a wagering contract, but still it is enforceable. Why? Because the government gets its revenue. Once you get the jackpot, 30% of it is deducted and goes towards the income tax. So the government gets its revenue. So horse racing is an exception to wagering contract. And mostly, lotteries. Of course, you know how many scams also took place as far as lotteries were concerned. Even in lotteries, all the persons who purchase a lottery ticket for 1 rupee or 10 rupees or whatever it is, they are not going to win. There's a chance of winning. For a moment, I'm not saying that you're not going to win. There's only a chance to win. And you try to speculate on that, and that your number should come and you should be the successful person. So the question is, as far as lotteries are concerned, lotteries are also legalized. Of course, I think most of you know, in Andhra Pradesh, you had that scam as far as Bhagya Lakshmi lotteries are concerned. Then after that, lotteries are banned. But today in Tamil Nadu, especially if you see, every pawn shop person or every small shop, they have run lotteries, Sikkim lotteries, Bhutan lotteries, Nepal lotteries, then Maldives lotteries, so on and so forth. God only knows whether those lotteries are held or not, but still you purchase a ticket and then you try to have hopes that you are going to win. There's a chance of winning or chance of losing. When that speculation is there, it is supposed to be a wagering contract, but still it is legalized. And the question is, in foreign countries, especially betting is legalized. And even in our country, we would not have so many scams as far as cricket betting is concerned, or otherwise, if betting is legalized. I think perhaps the day is not far off when the government may think of legalizing betting in all the games. Then we go to what is called the next section, sir, the most important chapter, called contingent contracts. What is the meaning? Section 31 defines a contingent contract as where it depends upon the happening or non-happening of an event which may happen or which may not happen. It is called a contingent contract. For example, suppose let us say here, suppose we say that we speculate on that by saying it is going to rain, and if it rains, of course it happens. then it depends upon the contingency. The contract is dependent upon that condition that it shall rain. But if it does not rain, it does not happen, the contingent contract becomes void. Of course, in our real life, these types of contracts do not arise for consideration. But here, uh, sometimes what happens is, suppose I tell my colleagues, sir, you must touch the sky with your little finger. And if you are successful in touching the sky with your little finger, I will pay you 10,000 rupees as price. Please remember, it is practically impossible for any person to touch the sky with his little finger. He may be the Hercules, or he may be the Goliath also, or he may be the Dara Singh, or he may be the King Kong also. The question is, the event becomes impossible. Suppose there is a contract between you and me that you shall walk 100 kilometers within 5 minutes. Please remember, even the best athlete in the world who has won medals or gold medals in the Olympics cannot run 100 kilometers within 5 minutes. But please remember, when it becomes impossible of performance, the question is, the contingent contract fails and it is void. Then the next one is, it is said contingent contract which are contingent on specified event happening within a fixed time. The question is, sometimes what happens is, a time frame is fixed. Within that time, if that condition that is imposed is complied with, the contingent contract becomes a valid contract. But in all other cases, a contingent contract is which becomes impossible of performance, which is incapable of performance, which is not possible by a human being to perform, then they are all supposed to be void and unenforceable. Then the next chapter is a very small chapter, sir. The question is performance, obligation of parties. What do you mean by performance of the contract? We don't enter into a contract just for fun's sake. We enter into a contract to see both the obligant as well as the other person complies with the terms of the contract, both in the letter as well as in the spirit. Just take an example. Here, suppose, let us say, I agree to sell my property to you for 50 lakhs and you agree to purchase the property for 50 lakhs. Then the question is, as far as I am concerned as the vendor, I must be prepared, ready and willing to sell my property and that agreed sale consideration. And you as the vendee or the purchaser, you must be ready and willing to pay that sale consideration and take the property. There the question of consideration is, I part with the ownership, possession of the property as a vendor, and you as the vendee pay the money and whatever the sale consideration agreed to. Then you are ready and willing to pay even if any balance is there, and you are ready to perform your obligations. Then the respective obligations on the side of the vendor or on the side of the vendee have to be performed in the letter as well as in the spirit. That is what section 37 says. Then 38 says, effect of refusal to accept offer or performance. Please remember, it is said that in the initial class itself I told you, an acceptance is an offer what a righted match is to a train of gunpowder. There cannot be an agreement unless the offer is accepted by the opposite side, number one. Number two, it is accepted within a particular time duration. If the time is fixed, then it should be accepted in the mode in which it has been specified, and it has to be accepted within the time that is prescribed, and it has to be a particular mode is prescribed, and in that particular mode you only have to accept it. Suppose you don't accept it, an offer is no doubt made, and the question is, you do not accept it or you do not perform your part of the contract fails and it cannot be performed. So the question is, offer plus acceptance is the essential sine qua non for a valid agreement. Unless both the ingredients are satisfied, there cannot be an agreement, and that agreement which is enforceable in a court of law, all the ingredients will have to be satisfied. So if the offer is not accepted, then the question is, offer fails and you cannot accept it later on. That's what section 38 deals with. Then the 38 and 39, they say the contract has to be performed as a whole. You cannot perform in a piecemeal manner unless the contract specifies it should be done in a piecemeal manner, it should be done in a phased manner, it should be done in installments, then alone you can do it. But if the contract specifies it should be done at one and the same time, it has to be done completely. You cannot pick and choose. Do something today, do later on. Something like a building construction. You cannot say that I will dig the foundation, then I will dig the I will lay the pillars after some time. The question is, unless it is specified, the question is the entire when I give a building contract, it is a duty of the contractor to not only accept it but also perform it as a whole. He cannot leave it just like that in an unfinished manner. That's what they say, section 30, section 30, 39, 39. Then we go to who has to perform. The next chapter deals with who has to perform. The person by whom effect of accepting performance from the, here who has to perform is, sometimes what happens is, I think the law of agency, sometimes it's not possible for the principal to do everything by himself. He does it through his agent, through his authorized representative, or to a person nominated for that particular purpose, and the third party ensures the insurer performs the obligations. Then suppose, let us say, the offerer accepts performance by a third party other than the person who has contracted for. He cannot complain of saying that there is no privity of contract and I have never accepted performance from a third person. Only the person to whom it is made has to perform. But if he accepts performance, it is a valid performance under the law. Then devolution of joint liabilities. What do you mean by devolution of joint liabilities? Joint liabilities is the classic case. You can say that suppose there are four people in a partnership firm. Let us say the firm incurs a debt of, let us say, about 50 lakhs. Then the question is, in the absence of any contract in the contract, the question is, it's a joint liability. Who has to discharge, sir? The firm has to discharge. Firm has no independent existence of its own. It is a combination of two or more persons who come together to start a business. As far as the liability of the firm is concerned, all the partners proportionately to their contribution are liable to contribute towards the debt. That is, as far as joint liabilities are concerned, joint liabilities has to be discharged individually and jointly by all the persons concerned who are parties to the contract. Then next one is here sometimes what happens is effect of acting perform third person, devolution of a joint liability, any one of the provisions can be complied. Here suppose let us say the contract contains of several terms. It has to be done in a systematic way. It has to be done in a phased way. It has to be done within a time frame. You cannot perform all the acts at one time. The question is, according to the time schedule that is given to you and according to that time, it has to be performed. Then, sir, we go to what is called sharing of loss by defaulting. That is sharing of loss by default in contribution. Here, as far as mostly it arises in the case of a firm, as far as losses are concerned, it has to be shared in the ratio or the proportion of the proportionate contribution made by the partners. Then release of one joint promisor, effect of it. What is, suppose let us say one promisor is there and let us say four promisors are there. One promisor is released. Then in that case, the other promisors can say that the other person is released without our consent. He should also be made liable. We alone are not liable to pay. The question is, effect of releasing one person without the consent of the other persons is illegal. Then devolution of joint rights. Joint rights is devolution of joint rights. Suppose let us say a firm purchases it and all the four partners have contributed to it. In the absence of any, suppose let us say a particular property is purchased in the joint names of three persons and let us say the property is purchased for 45 lakhs. The sale deed does not show as to what each person has contributed. Whether I've contributed 15, you have contributed 20, other persons contribute. In the absence of any contribution, proportionate contribution being mentioned in the sale deed, the question is all of them are entitled to equal rights, and it is deemed that they are entitled for one third, one third, one third. Are you able to follow, please? The question is, suppose the contribution is mentioned, proportionate contribution is mentioned, what each person has contributed is mentioned, then it goes according to that. But if it is not mentioned, the question is, all of them are equally entitled. That is, all of them are entitled for one third, one third, one third. That is as far as the performance is concerned. The next chapter is time and place. Here the first section is 46, certain date, time and place. Certain date is fixed for performance, certain time is fixed for performance, certain place is specified for performance, the site is shown to you, the building or the plot is shown to you, where you have to do it, what is the time within which you have to do it, then the place where you have to do it, and the time within which you have to complete, and then the date when it shall commence, when the contract specifies all the specifications, and according to that it has to be performed. The next one is where application is to be made. Here, suppose let us say I engage a contractor. Then let us say the contractor says, please intimate me, sir, when I should start my work, or please apply that I should start the construction. Then suppose let us say you must make the site available, you must make the house available, you must make the property available to start his work. But if you start placing impediments in his way, don't keep the site ready, don't give him the time where he has to start it, don't show him the place where it has to be done, or don't show him the what is called date on which it has to be commenced, then in that case, unless application is made to perform the contract, the question of performance doesn't arise. Then in most of the cases, no application is necessary. Once a contract is made, it shall be started forthwith. Then suppose the time is fixed, and let us say performance should be done within a time frame. Normally in development agreement, there is a clause normally added saying that the construction should be commenced and completed within a period of 18 months and subject to further extension by another 6 months in case of any difficulties. Then according to that, it has to be done, and it is normally prescribed in the terms of the contract itself. Then, sir, we go to reciprocal promises. What do you mean by reciprocal promises? Promises are not bound unless reciprocal promisee is ready and willing. Reciprocal is I make a promise, then the other side also makes a promise. Both the promises have to be accepted. Unless the other side accepts the promise, I need not accept it. So reciprocal. Reciprocal means where each one of them make promises. I make a promise, I as A make a promise. Then B, the other opposite side, has to accept it, or he has to express his willingness to do it. B makes a promise, then A has to accept it, and A has to be ready and willing to perform his obligation. So when reciprocal promises are there, both have to be performed simultaneously. That is, both have to be accepted simultaneously. Unless the opposite side accepts it and is ready and willing to perform his part of the contract, the question is, it is called a reciprocal promise. Then order of performance. What do you mean by order of performance? Order of performance is, first there is a building contract, I agree to hand over the site, I had placed the time, I place the place, and I also give you within what time it has to be done. Then the question is, then the other side says, you have to pay my money. When will it come, sir? Order of performance is first when the site is ready, when the site is shown to you, when the contract is made between the parties and the other party is ready and willing to do it, and then according to the time schedule, the question of payments have to be made, then it has to be performed in a manner and in the item that has been prescribed under the terms of the contract. I think with this we shall stop, and in the next video we will try to deal with section 53 to section 58. So the question is, the first part of it is almost fundamental and rudimentary, but when we come to the second part, we may have to dilate more time on that, because we deal with the three important chapters called specific contracts, indemnity guarantee, bailment, pawn and pledge, and then law of agency. And again, I repeat, there are certain sections which have been repealed in the Contracts Act, that is from section 76 to 123 and section 239 to 270, because these sections have now been included in a new act called Sale of Goods Act and Partnership Act. I think so this is being beamed on the YouTube. My admin will address you, sir.